Welcome to Winning Isn't Easy. I'm nationwide ERISA disability attorney Nancy Cavey. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association tells me that I've got to say this. And now I've said it, nothing will prevent me from giving you an easy to understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Now, disability carriers employ many denial strategies during the course of a claim, and I'm going to continue in this series of vocational evaluation, denial or termination tools. And I'm going to be talking specifically about three things. One is the Vocational Denial Toolbox. Two, the games that are played at the any occupation stage, and how carriers will misinterpret a claimant's work history based on jobs to purposely arrive at the wrong occupation. Before we get started, let's take a quick break.
Been robbed of your peace of mind by your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claims process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. Ready to get started? We've got a lot to cover. Let's first start out with the Vocational Denial Toolbox. They've got lots of denial tools in their toolbox. And at the own occupation stage, the disability carrier's in-house vocational evaluator will misinterpret the work history based on jobs to arrive at the wrong occupation. They'll misclassify the client's occupation. They'll misapprehend the occupational duties, as that term occupational duties is defined by the policy or the plan. They'll use the carrier or the plan's peer review or in-house provider's opinions about the restrictions and limitations to determine that the policyholder or plan beneficiary can perform their occupation. They'll also fail to identify and consider non-exertional impairments, and they'll fail to consider the combination of exertional and non-exertional impairments. Any one of those reasons or a combination of reasons are the basis to justify a claims denial or termination. I think that should be vigorously attacked in an appeal letter and in litigation. And so one of the crucial areas where there is the game playing is at the transition from the own occupation to any occupation. Now, what will happen here is that the definition of occupation is going to change at some point from an inability to do your own occupation to an inability to do any occupation. The claims denial will often come before the termination or conclusion of the own occupation period. And they do that on purpose. What they'll do is deny the claim so that you're forced to file an appeal on the balance of the own occupation benefits, and then basically stonewall you in applying for your any occupation benefits. And of course, what I want to do is to make sure that we're proceeding and appealing and working on both, if you will. Now, there are times when there's going to be where they will actually pay out the full own occupation benefits and then terminate at the any occupation stage. So what happens there? Well, it's the policy language that they will use when there's this transition from own occupation to any occupation. You need to get out the policy or plan and understand the definition of the occupation, any occupation, whether there's a requirement that the any occupation specifically be identified by the carrier or the plan in terms of a geographical requirement. And sometimes there is a requirement in the terms of the policy of the plan that any particular occupation they identify has to generate a certain amount of income so that if that job or that occupation pays a wage that's equal to or greater than, or even sometimes 80% less than what the before monthly earnings were, then no benefits are paid. So you've got to get out this policy or plan and read the definition of disability, own occupation, and any occupation, because those are the parameters that are going to be used in determining your entitlement to benefits and in drafting and creating a successful appeal. Got it? Let's take a quick break.